Then we are proceeding on In Re Estate of Virginia Durkin. Each party will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you plan to reserve time, let me know. I'll do my best to keep you apprised of your time. We've read your briefs. We are ready to proceed when you are. Ms. Morris, you are the appellant or representing the appellant in this case, so you begin, and before you start, let me know if you do wish to reserve time for rebuttal.
Thank you, Your Honor. Yes, I would like to reserve time for rebuttal.
And the only other thing I would say, although it looks like it's happening here, when you're not arguing, please mute your mic. I know Mr. O'Halloran, it appears as though he's already doing that. How much time do you want to reserve?
5 minutes.
All right, we are ready when you are.
Thank you. May it please the court. Mr. O'Halloran, I don't know if Ms. Williams and Ms. O'Halloran are present. I'd like to acknowledge their presence if they're here. Good morning. My name is Michelle Morris. I represent the estate of Virginia Durkin and the executor of that estate, John Durkin. Virginia Durkin died on August 29th of 2015 with a will. She appointed her son, John Durkin, to function as the executor of her estate. The estate essentially was a fairly straightforward administration of an estate. She, like I said, had a will. She left her estate in equal portions to her son and her daughter. Her daughter predeceased her, and her will provided for per stirpes distribution of her share of the inheritance to her 3 grandchildren, who are the appellees in this case and are pro se. Essentially, we're here, and this appeal is the second appeal in connection with this estate, and this is a procedural issue that we're before the court on now. The first appeal contained 8 assignments of error. That appeal was filed by Mr. O'Halloran. This court reviewed and considered and resolved all of the issues that were contained in that appeal by its order issued on June 13th of 2018, and remanded the case with a directive to the lower court to complete the administration of this estate in conformity with the mandate and the directive of this appellate court. When the court was remanded, it went back before Judge Stormer. She recused herself, and the Supreme Court appointed visiting judge Stephen Williams. Immediately after the case was reinstated in the probate court, Mr. O'Halloran began issuing subpoenas once again in the estate, which in itself was out of conformity with the directive of this court. Judge Williams then set the matter for a status conference. The status conference was conducted in April. At that status conference, Judge Williams basically admitted that he wasn't intending to rule on any of the motions concerning the outstanding subpoenas or any motions that had been filed by the estate to try and get the court to simply implement the directive of this court. Instead, the court was very upfront about the fact that he disagreed with this court's ruling in the prior appeal, and that he intended to reconsider removing the executor, even though that issue had been previously decided, and the lower court's initial decision to overrule a motion to remove the fiduciary was affirmed by this court. On remand, Judge Williams openly declared that he was in disagreement with that and that he intended to take another look at that. He set the matter for a hearing for that purpose. In May, conducted a hearing again, not ruling on any of the estate's motions, trying to direct the court's attention to the law of the case. and in that hearing allowed for the use of many documents that were never produced to the estate in the lower court. All of these issues were briefed and argued. In the first appeal, this court decided on all of those issues. Again, all of those issues were ignored, and the lower court proceeded with what the judge referred to as a hearing, although there was really no protocol for that hearing, and exhibits that had never been produced to the estate were used to interrogate the executor. Basically, the only issue before this court now is a procedural issue, that is whether the lower court abused its discretion when it exceeded the directive of this court and basically hit the reset button and started the administration of the case over by appointing a special magistrate to review all of the financial transactions that had occurred apparently from the time Mr. Durkin was appointed durable power of attorney for her mother, which had been 12 years prior to her death.
But counsel, I don't recall that the ninth, said that he couldn't do that.
Well, what this court said is that the lower court had properly denied the motion for removing the executor.
All right, and in reading I can't recall his name, so I'm going to say the visiting judge's order, I thought he specifically said he did not remove the executor.
Well, he essentially removed the executor by finding a way to get around removing the executor and putting a special commissioner on the case to do what would happen if the executor was removed, which is to go back and gather all the documentation that could and was required by law to be gathered at the first instance in the probate court when the matter was initially being administered before this first appeal. So on the basis of
could the judge have looked at some of that information again in conjunction? If I read our last order correctly, one of the things that had to get back when it got sent back, it was time to do the inventory. Was that a fair statement?
Correct.
Could the judge have looked at that information again now in terms of the inventory? In other words, it's my understanding, I think it's pretty clear, Mr. O'Halloran was challenging the inventory.
He was challenging the inventory and always had, and the manner in which he challenged it was considered by the lower court. In the first instance, it was part of the appeal to this court, and this court directed the lower court to proceed with the administration of the state, including an amended inventory that was consistent with what the lower court had decided in the first instance. And as soon as that was filed, it was attacked again in the same manner as it already had been. So this court had already determined those issues. And I mean, what even adds to that is that the documentation that was being utilized to support the conclusion that something new happened was documentation that had never been provided to the estate during the initial administration. There was actually a court order ordering the grandchildren to produce those documents. They didn't. And so that also contributes to the meaningfulness of this court's review of the lower court's initial administration of the estate and the proceedings that went on at that time. So essentially, there is nothing new. When it got remanded, the amended inventory was specifically to be done in accordance with this court's directive on remand And that meant following what the lower court had already, the orders that the lower court had already issued in the case, which is exactly what was being done. So, so Judge, I would.
You answered my question.
Okay, yeah. So I think that right from the get-go, Judge Williams was very upfront about the fact that he had no intentions of following what this court directed the lower court to do. He said he didn't agree with it. He thought it was a superficial review of the case, and he was going to basically do what he wanted to do. And in so doing,
Counsel, did he say that, or did he actually say we had never gotten to the merits, so he didn't think he was prohibited from doing so?
well, I mean, I actually quoted in my brief what the lower court said. So, you know, basically what he said is that he didn't feel that this court dealt with anything of substance. And, you know, ultimately he agreed with the grandchildren that there needed to be kind of, like I said earlier, hitting of the reset button. But what is so from the perspective of the estate is that he already had, the grandchildren already had their opportunity to do that. And they failed to do it in a way that was in accordance with the civil rules that all of us have to follow. And that there was no evidence to support the contentions that they were making, and the decisions that the probate court made, therefore, were affirmed by this court, and the case remanded to implement the findings in accordance with this court's directive, and that didn't happen. So,
Ms. Morris, I just want to let you know you're into your rebuttal time. You're welcome to continue, but I just want to keep you apprised of your time.
Okay, thank you. So, I mean, essentially, the estate contends that the order issued by Judge Williams on August 20th of 2019 violates the law of the case because the court had already considered and overruled the assignments of error, and that we're now before the court asking the court to require the lower court to adhere to this court's prior directive. Thank you.
Mr. O'Halloran, whenever you're ready.
Thank you, Your Honor. Good morning, Your Honors. My name is Daniel O'Halloran. I'm a pro se beneficiary in the probate case of Virginia Durkin. If I may, let me start with the matter of jurisdiction. Per Magistrate Walsh's order of January 30th, 2020, the issue of this court's jurisdiction to consider this appeal remains open. The appeal filed by Executor John Durkin and his attorney Morris is taken from an interlocutory order to appoint a master commissioner, an appointment that involves findings of fact. This is not a final appealable order, nor does it affect any special right of the appellant, John Durkin, and accordingly, this appeal should be dismissed by this court. In trying to establish grounds for filing this appeal, Attorney Morris repeatedly makes the false assertion that appointing a master commissioner is equivalent to removal of a fiduciary. She fails to point to any laws, case law, or rules to establish this equivalence. And frankly, I don't think she could, because I couldn't find any that would support that assertion. Let me now move on beyond the matter of jurisdiction and start by emphasizing three important points. John Durkin held power of attorney over Virginia Durkin while she was alive, and is required by law, the Uniform Power of Attorney Act, to have kept complete records of all transactions he made using that power of attorney. During the May 21st, 2019 hearing, he said he had thrown out these records. Point two, furthermore, John Durkin is required by law to turn over all documentation of his activities as power of attorney to interested beneficiaries when requested. But him and his attorneys have refused to do so since the beginning of this case nearly 5 years ago, and falsely claim the beneficiaries have no right to the information. Point three, as this court is aware, the lower court prior to the first appeal found John Durkin had committed at least 2 acts of self-dealing in his capacity as power of attorney. In summary of these 3 points, as a beneficiary, I have a right to all documentation concerning transactions made by John Durkin, acting with power of attorney over Virginia Durkin prior to her death. Since John Durkin and his attorneys have repeatedly refused to provide that information and attempted to block all steps I took to conduct discovery on my own, it's perfectly reasonable for Judge Williams and the lower court to appoint a master commissioner to carry out a fact-finding mission to recover this documentation. As Your Honor pointed out, Ms. Morris is trying to extend the rulings of this appellate court to matters that were not ruled upon in the first appeal. For instance, this court did not reverse the lower court's decision to deny my motion to compel. Ms. Morris and John Durkin seem to indicate that they think this means the fiduciary, John Durkin, is relieved from his legal duty to provide information regarding his activities as a power of attorney to the beneficiaries. This is simply not true, and I believe is a reckless and lawless extension of the ruling of this court. In another instance, this court affirmed the lower court's decision not to follow through on my motion to remove fiduciary. However, that does not in any way restrict the lower court's authority to sua sponte consider removal of the fiduciary. I will also point out that despite this court's ruling on the matter, there was never a hearing in the lower court prior to the first appeal on the matter of removing a fiduciary. So one could argue that removing a fiduciary was never properly considered by the lower court, regardless of the error that was affirmed or not reversed. The first hearing on the matter of whether or not to remove a fiduciary didn't occur until Judge Williams took over the case and scheduled an evidentiary hearing for May 21st, 2019. Despite the contentious nature of this case, this was only the second evidentiary hearing to be held in the entire 5 years proceedings. Nonetheless, as Your Honor has pointed out, Judge Williams decided not to remove the fiduciary at this time, but shared significant concerns after the hearing that not all assets were being properly included in the estate, and accordingly appointed a master commissioner to be finder of fact on the matter. Ms. Morris has claimed numerous times in her brief and even repeated today that she never got the evidence that was used at the May 21st, 2019 hearing. But all of that evidence, as Your Honors could see, was included in my objections to the amended inventory. And as Your Honors correctly pointed out, I had a right to file objections to an amended inventory. I never had an opportunity to file that evidence previously because the case was closed at the lower level before I ever got that opportunity. So it's part of the record, and I believe Judge Williams was proper in reviewing it. Also, Ms. Morris and her client, John Durkin, claimed that they never had a chance to review this information, except they received it as part of the objection to the amended inventory, which they would have had to if they were filing motions to strike it. And that was 88 days before the May 21st hearing. So they obviously had plenty of time to review that information. Also, as a fiduciary and as power of attorney, John Durkin had all these documents during his tenure as power of attorney. So to say that he had never seen them before just doesn't make any sense. I believe Judge Williams absolutely had the authority to review new evidence at the May 21st, 2019 hearing. And there's no reason to think it did not have a bearing on his decision to appoint a master commissioner. So this is new information that was not present before the first appeal. I don't believe any ruling by this court impeded the lower court's authority to appoint a master commissioner, as Your Honor pointed out earlier. As this court ruled in the previous appeal and countless other cases, the lower court has the authority to direct and control its own discovery. Appointing a master commissioner is a fact-finding order and not an appealable matter.
Well, doesn't it matter how you have appointed the master commissioner, though? In other words, what role you give him or her?
Well, I mean, the role is as a fact finder to get the information that John Durkin, as a power of attorney, has refused to turn over. He's legally required to provide that information and has refused to for this entire case. So, I mean, I don't understand. I don't see how there could be any out whether he can simply not turn over information. And furthermore, why would he not turn over this information if he had nothing to hide? Why would they go to such extreme lengths to block discovery if John Durkin had nothing to hide? I think the answer is pretty obvious, and the evidence that I presented during the May 21st hearing shows many more instances of self-dealing. So it seems very reasonable for a master commissioner to go in and get all of the information that John Durkin was legally required to share in the first place. I won't get into too deeply, but if Ms. Morris has relied a lot on the law of the case doctrine, and if this court believes that any of that is valid, though I do not believe, first of all, Judge Williams never said he was disregarding the rulings of this court. That's just a completely false statement. You've read his motions, or you've read his order. As you said, he believes you didn't get to certain issues. That's very different than saying he was going to ignore your orders. So one of the things is, before we had this new judge, we had a different judge, Judge Stormer, which I filed an affidavit to have her disqualified, and she recused herself afterwards. And I put it in the brief. There's a lot to consider there in how tainted this case was in the first phase because of what seems like pretty obvious preferential treatment for John Durkin and his attorney, who has since been convicted of a felony offense and suspended from the practice of law. The bottom line is that a probate case is supposed to ensure the fair distribution of the assets. It's simply logical to think that a fair distribution is currently in place when 300 plus pages of evidence show numerous transactions by John Durkin using power of attorney to indicate further self-dealing on top of the 2 instances that are already a matter of law case in this doctrine. Though I don't believe law of the case doctrine is relevant to any of the actions taken by Judge Williams in this probate case, I would say that if they were, then this course should look at whether or not law of the case doctrine would lead to an unjust outcome, meaning basically, if we ignore all this new evidence, is the estate going to be distributed the way it was intended to be and fairly? Or is it an unjust result because we're turning a blind eye to activities by a individual with power of attorney who refuses to disclose that, which is like one of the primary responsibilities of a power of attorney, is you can't hide your activity. You can't hide what you did for the principal. So I believe it's unjust for John Durkin and his lawyers to try to use legal and procedural maneuvering to block the disclosure of information he's legally obligated to provide to the beneficiaries. And accordingly, I asked this court to affirm Judge Stephen Williams' order to appoint a master commissioner to properly investigate the estate and gather all documentation that has been withheld. Thank you, Your Honors.
All right, thank you. Ms. Morris, you have about 3 minutes and 49 seconds.
Thank you. I just want to touch on a couple points that Mr. O'Halloran raises. And the thing that I really want to emphasize is that there are not any new issues that are being presented by this court. There aren't new issues. The arguments that he's making were made below, and they were dealt with by the lower court, and those issues were briefed in the prior appeal and considered by this court. With respect to the discovery issues, it is true that Mr. O'Halloran provided a stack of documents and attached them to his objections to the amended inventory. That was the first production of copies of documents that he received years earlier. There was no connection to the subpoenas that he obtained those from. So to suggest that that somehow complies with the civil rules is ludicrous. And while I understand that he is unrepresented by counsel, he is still required to follow the same rules. So it is absolutely not a false statement that headed into what was characterized as an evidentiary hearing. Those documents were not produced in a way that was in any way close to complying with the civil rules. And in fact, the lower court had found him in contempt for not producing those documents he was under an order to produce. He still didn't produce them. He didn't produce them after this court said that it was an error and that he should have produced them. So this is, again, not a new issue. And with respect to the durable power of attorney, again, the discovery in the lower court still had to comply with the civil rules, and they did not. So I don't want to rehash the facts that led up to the first appeal, but I can't resist saying again that Virginia Durkin, she was never under guardianship. She handled her own finances. She had her financial records, not Mr. Durkin. All of that evidence is in the record. So again, there are not new issues here. The courts
Mr. Durkin did have power of attorney on
he did.
something, correct?
He did, yes. But the administration of the estate, the context of the accusations against Mr. Durkin were within the administration of the estate. Those issues were managed by the lower court. They were considered and heard by the lower court. And that is all in the previous appeal. And it's also in the current brief demonstrating that these are not new issues. So with respect to the law of the case, yes, the administration, the estate is asking the court to follow the law of the case doctrine here, which is very on point with the Nolan case by the Ohio Supreme Court, where, like in the Nolan case here, when this court remanded the case, the lower court went beyond this court's directive. And in doing that, when it expanded its scope, it violated the law of the case doctrine. And we are simply here asking this court to require the lower court to do what this court told it to do back in June of 2018. Thank you.
All right. Thank you both for your arguments. We will take the matter under advisement, issue our written decision in due course. It will be mailed to both sides, as well as posted on our website and to that of the Supreme Court. I just want to say one thing just for housekeeping. Mr. O'Halloran, you are the only appellee in this case. I know that your certificate of service has served what you called your co-appellees. Hang on for a second. They are technically not. So I guess what I'm telling you is we won't be serving them. So when we give you notice, you make sure you tell them.
Yes, Your
okay,
Honor.
fair
Yep.
enough. All right.
Yep.
All right. Both of you have a great day.
Thank you, Your Honors.
Sure.